Good morning, sir. And Mr. Topol, excellent.
Morning.
Very
Good
good.
morning.
Good morning, gentlemen. All right, Mr. Topol, we are ready to proceed with your argument. And how much time do you wish to reserve for rebuttal, sir?
If I could just reserve 2 minutes, that would be great.
2 minutes? Very good. And whenever you're ready, sir, we are ready.
Thank you very much, Your Honor. Adam Topel here on behalf of SafePoint Insurance Company, the petitioner. So in this case, SafePoint is seeking a writ of certiorari, and specifically a writ that quashes a trial court discovery order compelling disclosure of protected materials from SafePoint's underwriting file. So just to provide a brief overview, the plaintiff, Carl Abel, filed the underlying action against SafePoint alleging breach of an insurance policy. He claims that SafePoint breached a policy by failing to provide coverage for certain alleged damage to his home. And so the underlying dispute is one over coverage. There hasn't been any claim of bad faith asserted yet or anything to that effect. So the plaintiff propounded discovery requests on SafePoint, and the plaintiff sought a number of materials from SafePoint's underwriting file.
Nothing from the claim file, right?
Yeah, to clarify, these materials are from the underwriting file.
Right, and what they're trying to get at is the condition of the property prior to you issuing the policy, correct?
That's my understanding, correct?
And is that based on your anticipated defense that this damage pre-existed the issuance of the policy?
That's my understanding based on the representations in there.
So what's the problem? It's not claims file material. It's related to your defense. It's like we just want to see what information they had based on their inspection, their photographs, their underwriting before they issued the policy. What's the problem?
Well, first of all,
what's the problem with that?
Well, the problem.
Tell me why that's not discoverable.
The problem is one of the materials that the trial court ordered production of were the underwriting guidelines in effect at the time the policy was issued.
I think it said in the answer or the response that those are filed publicly. Those are public record.
If that's the case, then I think that problem is theirs, because in order to get.
Well, no, it's your problem that they're not privileged, and they've asked you to produce them.
And actually, to follow up with, I think you conceded, the petitioner did concede below that it is a publicly available document. And so that to follow up with Judge Kelly's statement.
Well, nonetheless, the case law indicates that these types of underwriting materials, these are pertain to the business policies and practices of SafePoint. They are nonetheless protected.
There was no, and even if they weren't publicly available, it would have been incumbent on your client to make a proprietary information objection, because these are not part of a claim handling issue, certainly underwriting guidelines. And that wasn't made, and we know that they're public because they're filed with the OIR. So that kind of leaves you with the photographs and inspection that, we all agree that those are underwriting documents. And tell us how those relate to being prepared in anticipation of litigation, because that's what work product is. And it's very hard for me to understand how an underwriting inspection that was made before the policy was issued could have been prepared in anticipation of litigation.
Well, the case law indicates that these types of materials are non-discoverable actually for at least a couple of reasons. And it could be privilege. It could be because these were prepared in anticipation of litigation. But the case law also indicates that these are non-discoverable simply because they're irrelevant in these types of.
Then we get to certiorari jurisdiction. Relevance.
Well, okay, our petition is really predicated on this court's decision in Owners versus Armour. That's really what we're basing everything on. And in that case,
Mr. Topol, let's focus on this case here. I know you're making generalized statement as to what the law is, but it goes back to what Judge Kelly initially asked you. You said that this deals with, it should be that this topic, it's irrelevant. But didn't Judge Kelly, and you basically indicate, you're taking the position that this type of damage occurred before the policy. And so that makes it really relevant. You're trying to pictures to make a determination whether or not to even insure this particular appellee. And so this was before anything was done. So how can the argument be made that number one, it is irrelevant, or number two, that it is done in anticipation of litigation, considering it hasn't even, no claim has been made. And all the cases that you're alluding to, those are all different because claims have been made in those cases. So how do you respond to that, if you don't mind, Mr. Topol?
My response is simply this: the case law, like Owners versus Armour, indicate that these types of materials are non-discoverable. And it's—
Wait, what types of materials?
well,
You again, Judge Kuzan just asked you to be specific to this case, and you keep, I want to be candid with you. Your argument borders on bad faith and frivolous, in my view, because you keep characterizing these materials as claims file materials instead of dealing specifically with the fact that you have asserted a defense that these materials directly relate to, and you refuse to acknowledge that they're not claims files materials when they clearly are not. So please give a specific answer to Judge Kuzan's question.
okay, I acknowledge that these are underwriting materials, and I have no intention of representing otherwise or trying to mislead or whatnot. My only response is that under cases like Owners versus Armour, and that's really, I apologize if that's improper to keep relying on this case, but that's the precedent that this petition is based on. And those cases indicate that these types of materials are simply non-discoverable because they pertain to the business and policies and practices of the insurer. And that's
now you're talking about the stuff, the guidelines that are in the OIR's files. And your client didn't make a proprietary objection to them anyway. So, and they're not work product. We think you've agreed to that at this point.
Well,
and just to follow up one last point, I think you're kind of stuck with two different sides out of your mouth argument on relevance versus irrelevance. But even if we accept, for purposes of this argument, that the inspection report and whatnot is irrelevant, then we don't have certiorari jurisdiction because there's no irreparable harm.
Well, this court has indicated that discovery of carte blanche, granting of carte blanche discovery of irrelevant materials does pose the type of irreparable harm that gives.
Well, I think you're referring to the case that you cited in your brief involving a deposition, the Armour case, which didn't involve documents. It basically set up an open season deposition where claims file material and other clearly work product privilege was implicated.
Yes, that's
here
true.
We're talking about the inspection report and photographs.
Right. We don't really see a material distinction between the types of materials sought in that case and the types of materials sought in this case. Because ultimately what they wanted to question about in Armour was they were seeking testimony about the underwriting of the specific policies referenced in the complaint, including, quote, the application submitted, the underwriting department's application review process, and the underwriting decisions made in assisting the insured with procurement of the specific policies at issue in this litigation. And so those are beyond just guidelines. Those two encompass actual underwriting decisions, and those presumably were made well in advance of any claim, just by necessity. So, and yet in that case, this court held that those parameters were too overbroad. And on that basis, this court issued a writ quashing the trial court's order to the extent it had allowed questioning into those areas, and it remanded for further proceedings. So
am I misunderstanding that the relief granted here by the trial court, the discovery that was allowed, was specific to the condition of the property as it existed prior to your issuing the policy?
Well, the order itself said the defendant is ordered to produce the inspection report as listed on the privilege log, as well as the photographs contained in the inspection report in digital format, And then as to number 9, the defendant is ordered to produce its underwriting guidelines in effect when the policy was issued within 30 days. So those were the 2 categories that were ultimately
Right,
ordered.
so that's a very specific order. I mean, do you not see the distinction there?
Well, we don't see any material distinction, to be perfectly candid. We think this falls squarely within the purview of owners versus armor.
Well, let me ask you this question. Let's say you pursue this defense that this condition existed before we issued the policy. So how are they supposed to respond to that? Just say, no, it didn't, and you're going to have to say, prove it, or yeah, yes, it did, but they knew it? Then would, you know, I mean,
I mean, I think
how
it's
is
a,
it, how is it not relevant? I'm really struggling with that.
I think, you know, they can come up with this.
Like, you get to say this, you get to say, oh, no, this existed before.
Well-
And, but we're going to hide the ball about what we knew.
I mean, ultimately, if they, assuming this could somehow be discoverable, which we still dispute, they still have to demonstrate a need for these materials and an undue hardship from obtaining them from other sources.
Well, how can they prove what you knew or what information you had prior to issuing the policy short of getting these materials? How do they prove that? What other way can they do it?
I think it's the burden is on them to demonstrate the need and the undue hardship.
Well, I'm asking you, how would they prove it?
The need and the undue hardship.
Yes. What other way what else could they look to establish the knowledge that you had when you issued this policy, short of looking at your file, your underwriting file with the photographs and the inspection report?
I mean, I can't say. I mean, to be honest, I think it's their case to try, but the reality is it's their burden. It's their burden to demonstrate the need.
So you can't think of a way they could prove it, but you think maybe they can think of a way. That's what you're saying?
I think so.
Okay, all right.
If there are no further questions at this point, I'll just reserve the rest of my time for rebuttal.
Very good. Thank you, sir. Okay, Mr. Nation, I'm going to ask you, Mr. Topol, to please mute your microphone. Mr. Nation, whenever you're ready, the court is ready for you, sir.
Yes, Your Honors, thank you. I really don't have an argument to make other than what we have in our papers. The court obviously understands the issue, and I'm available for any questions you have on this.
Very good. I don't have any questions. Judge
No.
Kelly? Very good.
No,
Thank you, Mr. Nation. We appreciate it.
Thank you all.
I'm
Thank
going
you.
to ask you to mute your microphone to Mr. Topol if you wish for a brief rebuttal, sir, if you wish.
I have no rebuttal. I'll just ask that this court respectfully issue a writ of certiorari quashing the trial court's discovery order.
Very good. Thank you, gentlemen. So at this time, I'm going to ask you to please exit and let me ask the panel members, are you all okay to go one more? Would you wish to take a recess right now? I forgot to communicate that with you. We'll do one more? One more? Judge Kelly, I think. Oh, sorry. Yeah.
I'm fine
Bye-bye,
either way.
everybody.
Thank you, Mr. Nation. Well, let's do this. Let's go ahead and do one more, then we'll take our more.